Hello everybody, good evening. I'm Frances Crook, I'm the Chief Executive of the Howard League for Penal Reform, and I want to welcome you here this evening and thank Clifford Chance for their hospitality. Coffees and biscuits before, drinks and eaties afterwards, it's wonderful. So thank you very much, Clifford Chance. Now, I'm just going to say a few words. I'm going to take this opportunity to say a few words before I introduce Nick. It's the Howard League's birthday this year. We are 150 years old, and there are very few organisations in this country, never mind voluntary organisations, that have survived doing pretty much the same sort of thing for 150 years. And things have changed. Don't forget, we were founded in a year when this country got rid of public executions. So, you know, there has been progress. Sometimes it's 2 steps forwards and 1 step back, but just bear that in mind. Now, what I'm going to do is an absolutely unabashed fundraising plea. It's our birthday. Give us a present. It's nice and simple. Now, there are 2 things you can do. You were handed a membership form when you came in, and if you're not a member, fill that in now. I'm watching. If you don't have a pen, my staff have pens. We gave you a Wi-Fi code, so you can do it on the internet if you want to as well, on the website. If you are already a member, thank you. But you can also give to something we're launching today, which is a crowd justice funding, because the Howard League has partnered with the Prisoners Advice Service to take a judicial review, which is unfunded and very risky, to challenge the government. Now I'm going to read this because I have to get it right because my lawyers are listening. And I'm not a lawyer. Now, we're launching a new appeal for one-off donations, and it's the legal aid cuts to prison law that have resulted in prisoners' access to justice being severely curtailed. So help us challenge this in the courts. I tell you, we've been challenging this. The case has been going on for 3 years. It's very complicated. There you go. Oh, look. It's fantastic because we launched it today, and last time I looked, there was £800. So that's nice. It's working. Legal aid for prisoners, including children, was severely cut in December 2013. You know who was the Secretary of State in 2013, don't you? I don't need to mention his name, so remember that. Since the cuts have come into force, conditions in prisons have deteriorated sharply, as you will know and have heard yesterday with the terrible tragedy in Canterville. Violence and self-injury have risen to record levels, and more than 270 people, since the cuts in legal aid, have taken their own lives in prisons. 270. Now, calls to both the Prisoners Advice Service and the Howard League asking for help have increased by more than 50%. And the Howard League and Prison Advice Service are challenging the cuts because allowing all prisoners equal access to justice is a hallmark of a civilised society. Now, the Court of Appeal is going to hear our case in January. The impact of the cuts has been far-reaching. It means that a child, for example, held in solitary confinement, and yes, we do put children in solitary confinement in this country, cannot challenge their isolation. Well, they can through us because we help them, but they can't get legal aid for it. They can't get legal aid for disabled prisoners who need support packages so they can be released safely. It means a prisoner who's been considered by the Parole Board to transfer to an open prison but not for release cannot get legal representation unless they can pay for it, and very few prisons can do that. So you can donate online to the website, or both, please. That's fine. You can give both to this and join. Give the Howard League a 150th birthday gift. We need to carry on for another 150 years. Justice is something that evolves and changes. There's no right answer. Well, there are some right answers, and I keep telling people. But it's an evolving thing, so we need to carry on for another 150 years. We don't take money from the government, so we rely on your generosity. And yes, there are going to be people standing at the back who are going to ask you for your forms when you go, so fill it in now. I can't see you writing. And if anyone's handed it over, you can if anyone's completed it, you can hand it over now, the staff will collect it. Thank you for your generosity. I'm sorry to badger you, but if we don't get the money, we can't do the work. Because, as I say, we are completely independent and we don't take money from the government. And there are very few charities that can say that now. It is my extreme pleasure to introduce one of my very favourite speakers, and definitely my favourite Chief Inspector of Prisons, Nick Hardwick. Don't tell anyone that. Don't tell the others, will you? He's giving our annual lecture in memory of Lord Parmoor, Milo Cripps, who was a very generous donor to our work and who we commemorate every year. He gave a lot of money to help us keep doing our work. Nick, of course, was Chief Inspector of Prisons for 6 years and is now Chair of the Parole Board and Professor of Law, Visiting Professor of Law at the Royal Holloway University of London. And he's going to talk on as a really lovely topic. It's so nice to hear people being positive sometimes. Hope, the missing ingredient in prison reform. Nick, thank you.
Thank you very much for that introduction, Francis. It's very nice to be back at a Howard League event, and good evening to you all. It's a real genuine honour and a surprise, I have to say, to be asked to follow in the footsteps of some very distinguished people who've given this lecture before, but I shall do my best not to disappoint. The first time I ever spoke at a Howard League event was at your AGM in November 2011, and I spoke about this man. People have heard me speak before, and I always use this slide. Spoke about this man, who is John Howard, the 18th century prison reformer, who might have been called the first prison inspector, and after whom the Howard League is named. And this is a 19th century representation of him. And a surprising amount of what John Howard said in his great book, The State of Prisons, is still applicable today. So I thought I'd see what he had to say about parole. And this is what he said about the parole system in Holland some 250 years ago, and I quote, "Offenders are often sentenced to these houses according to their crimes for 7, 10, 15, 20 years and upwards, but to prevent despair, seldom for life. As an encouragement to sobriety and industry, those who distinguish themselves by such behaviour are discharged before the expiration of their term. A little before the election of new magistrates, those who are in office inspect the prisons and inquire of the keeper which prisoners, of those who have been confined a few years, have been diligent and orderly, and of the minister, which of them have been most attentive to public and private instructions. According to the accounts, they abridge the appointed time of punishment, so that 14 years will sometimes be reduced to 8 or 10, and 12 years to 6 or 7. This practice is in every view wise and beneficial. Indeed, I have some reason to think that criminals are often doomed to a longer term with the intention to make such deduction upon their amendment," which sounds pretty much like the parole system today. In fact, it's a bit like an IPP sentence, which is a bit worrying. But before we get too carried away with John Howard's fortune-telling abilities, I noticed that in the passage before he wrote that, when he was also talking about the Dutch penal system, he appears to praise the Dutch practice of the time of conducting particularly gruesome public executions. And he wrote that these were performed with great order and seriousness and great effect on the spectators. So I'm not sure that John Howard, in every respect, is something you'd want to emulate today. But there's a lesson there, right? That things that were once accepted as normal, even by men as enlightened as John Howard, we would regard with horror today. And I think that some of the things that we accept as inevitable today will appall some of those who come after us. And there's a message of hope there that things can change for the better, however impossible it might sometimes seem. And as Francis said, I want to speak about hope today. And that may sound like a strange topic after the dreadful events at Canterville earlier this week, and at a time when the prison service in England and Wales is grappling with such severe problems. And I don't want to diminish those problems, about which I'll say more in a minute. But the hope that things can get better is a necessary characteristic for anyone interested in prison reform, and the ability or the need to hope is part of what makes us human. And hope, or the lack of it, is an important thing to think about when considering the complex ethical and practical issues involved in parole. And by that I mean not just passively hoping for the best, but the belief that if organisations and individuals do the right thing and work hard enough, change is possible. But looking at what is happening in many of our prisons today, you might be forgiven for thinking that the situation is hopeless. And there are two things I want to say about the dreadful incident at Canterville earlier this week. We don't know the circumstances of the incident, but we do know it will have been traumatic and very frightening for the prisoners who are still held there and the staff who have to work there still. And more than that, imagine you're the partner or mother of a prisoner who's still there, locked down, unable to phone. Imagine you're the partner or mother of one of the men or women who had to go back in there to work today. Imagine that. I don't think we should add to their distress by speculating on the specific circumstances of the incident. But I'll say this, I do know for a fact that many of those who work in Canterville do so out of a sense of vocation, because this is where the need is greatest. Canterville has probably the neediest, most diverse and constantly changing population in the whole prison estate. This is a line from the introduction to the Inspectorate's last but one report on Canterville in 2013. It didn't get much coverage at the time, but I said this: many staff and managers, and I'm quoting here, many staff and managers worked heroically against the odds, but despite their best efforts, we remain very concerned about many aspects of the prison. Staff worked heroically against the odds. I remember being in the central hub of the prison, from which the wings or spurs at Canterville radiate off like spokes of a wheel. And it was the middle of movement, and 3 alarms went off at the same time. And one I know was a man having an acute and violent psychotic episode. Staff were rushing about this way and that to help. Prisoners were milling about, and the atmosphere was crackling with tension. And in the middle of all of that, as calm and focused as you like, while she issued instructions and brought the situation back under control, was a single young custodial manager. And I watched her do all of that from behind the safety of a gate. And I thought, if it'd been me, I would have been hiding under the desk. There'll be staff in Canterville now, as I speak, doing much the same thing. And there'll be prisoners in Canterville too, who tonight will be playing their part in calming things down, comforting their fellows, comforting staff. And I know that the managers in NOMS too will stay awake tonight, grappling with the impossible moral and practical choices forced on them by the reduction in funds the prison service receives. Volunteering community and faith groups trying to help. And I was in Canterville at an event last week and met staff, prisoners and managers and outside groups who are doing just that. We have indeed reached a dark place, as the Prison Governors Association have said, but we should draw hope and be inspired by the staff and prisoners and others who are still trying to light a candle. And whatever the circumstances of the individual incident at Canterville, at its root, lie political decisions about resources and staff levels, and it will take political decisions to put things right. And the next thing I want to say about Canterville is this. Don't tell me you are surprised by what happened. For most years, since 2007, when the data is published, homicides in prisons were a terrible but rare event. In the year to June 2007, there was 1. In 2008, 0. 2009, 3. 2010, 0. 2011, 2. 2012, 1. 2013, 2. 2014, 3. And then the numbers increased to levels not seen for years. 2015, 7. 2016, 5. So far, 5. That was before, this later be 6 now. And I don't believe this recent increase is a coincidence. It's the most extreme example of the decline in safety that I and many others in this room have been warning about for years. I don't now have the day-to-day knowledge of what's happening on the ground as I did when I was Chief Inspector of Prisons, but the latest non-safety data is appalling. And I know this will be familiar to many of you, but it's important to understand what it means. This is the most recently published data, and it shows the change since the same period last year. I won't go through it, but just take a minute to look at that. It's not just that these figures are bad, it's that now they are the worst they've ever been. It's not just that they're the worst that they've ever been, but that they're getting worse still. And it's not just that they're getting worse still, but the rate at which they're getting worse is accelerating. I can't say they weren't warned. If you read the annual reports I published as Chief Inspector, just as one example, they chart year by year the accelerating decline in prison safety. And some of you will recall that these warnings were very unwelcome in some quarters and led to some very public rows. Well, I was right. And the situation is now more serious than ever. And the meaning of the increase in suicides, assaults and murders we're seeing now is not just the awful consequences for the prisoners' staff and families involved, but the evidence they provide of a loss of control of our prisons. And by this, I don't just mean just or even mainly locks and bars and force, but dynamic security, the relationships, the trust on which prison safety and security depend, and all of which takes skilled staff time to provide. And I tell you, in these circumstances, ambitious plans to improve rehabilitation and education and tackle extremism are simply not achievable. And I see no sign that the number of homicides, self-inflicted deaths, self-harm incidents and assaults will not continue to rise. I choose my words cautiously. Politicians, policymakers and senior managers need now to think through very, very carefully and honestly the consequences of what further deterioration will look like and how this might all end up. Now, I've got the greatest respect for the Prison Governors Association, and I take their call for a public inquiry as a cry of anguish. But the last thing we need now is to wait years for an inquiry before action is taken. Do we not know what the problem is? Do we not know what urgently needs to be done to solve it? There are a number of factors, of course, but it's quite clear to me that safety in prisons will not improve unless there's a very substantial increase in staffing levels. Now, the grounds for hope in all of this is that certainly over the last couple of months, I've not met anyone in the ministry, in the prison service or in the Ministry of Justice, including, and I don't think this is giving away any secrets to say, including the new Secretary of State and ministers who doesn't understand that. You go into the room, what's different now, this is the first thing they want to talk to you about. Politicians don't need me to speak for them, but I do think new ministers in the MOJ understand the gravity of the situation, and they're trying at least to get a grip. But the £14 million that's been announced to provide 400 extra staff is targeted just on the 10 worst prisons. It's welcome, of course, but it doesn't in any way compensate for the thousands of staff who've been taken out of prisons over the last few years, and I'm afraid there's a lot more than 10 prisons that are in trouble. The 400 extra staff must just be the first step. The problem is now of such a scale, and the resources required to address it so significant that it will take a government-wide commitment to address it in the next spending round. And whether government as a whole understands the problem, I just don't know. But I don't believe in any case that making prisons safer again should be the end of the story. And I reject the view that there's a choice to be made between the need to improve safety and the need for wider reform. Analogies between schools and prisons are overdone, I think, but there are some valid comparisons. If you were trying to turn around a failing school, the first thing you'd do would be to restore order and discipline. But that wouldn't be an end in itself. It would be a necessary precondition to enable the children there to achieve their potential, exam results and so on, that were the real objectives of the school. So safety, security and decency in prisons shouldn't be seen as ends in themselves, but the necessary preconditions for rehabilitation and education outcomes to be achieved. And despite, or even perhaps because of the present challenges in the prison system, the time is right for reform. Listen to the recent debates in Parliament. Prison reform has received cross-party support in a way that would have been unimaginable a few years ago. In Murray polls, are the most important issues facing Britain today. 55% said it was crime, law and order and violence and vandalism in August 2007. That had fallen to 14% in August 2016. Look at the ideas for reform coming out of the States, from organisations like the Republican Right on Crime movement, where Trump supporters are producing ideas that wouldn't look out of place on a Howard League website. Oh, that might be stretching it a bit, but not too much, not too much. And the newly revised United Nations Standard Minimum Rules for the Treatment of Prisoners, known as the Nelson Mandela Rules, to which the UK as a party provide an important set of standards which, if implemented, would lead to real improvements here. The times are more favourable to prison reform than they've been for years, and we've got a duty not to miss the opportunity. In the next few days, the Royal Society of Arts will publish their blueprint for community-based rehabilitative prisons, and I commend it to you. You don't have to agree with every jot and comma to applaud the fact that someone is describing a practical path to a better future. And they recognise the critical relationships between staff levels and safety, but go on to describe steps to make rehabilitation central to safe prisons, with control decentralised, staff given the training and support commensurate with the complexities of their roles, and inspection powers consistent with international standards and placed on a much clearer statutory footing. The prison service patient doesn't just need emergency treatment to deal with its current critical condition, but a different and healthier lifestyle going forward to prevent the same sickness occurring again. I welcome the change of tone and sense of vision Michael Gove, the previous Secretary of State, brought to the question of prison reform, but like others, I was impatient to see results on the ground. And if Liz Truss, the new Secretary of State, now focuses on the delivery rather than the rhetoric, that I think would be no bad thing. So I'll now turn to the question of parole. First, I want to say something about prisoners and the victims of crimes they commit. I'm really uncomfortable about a description of prisoners that puts them simply as the products of their backgrounds with no real responsibility for the choices that led them to their current situation. For one thing, in my experience, prisoners themselves think you're ridiculous if you believe that. We all know the statistics about the disadvantage many prisoners have suffered. But despite that, they've made choices. And to portray them simply as the powerless products of circumstances beyond their control dehumanises them. And worse than that, denying them the possibility to choose denies them the possibility of deciding to change. They simply become the recipients of processes done to them rather than agents in their own destiny. Many of the prisoners who come before the Parole Board have done terrible things. The distress they cause lives on through generations. Yet the victims and victims groups I've met haven't been demanding vengeance. They may find the prospect of parole distressing, but so the ones I've met dealt with the process with real grace. What they do legitimately expect, and too often don't get in all parts of the criminal justice system, is to be treated with courtesy and empathy and to receive the practical and emotional support that those who suffered a sudden and awful loss require. And I've been impressed by the work of some of the victim groups I've met and think they make a very strong case for better financial support. I don't think that the interests of those concerned about prison reform and parole and those concerned about the victims of crime are in fact very different. What most victims I've met have said to me is they don't want more people to suffer as they have suffered. And of course, safe rehabilitative prisons can play a part in reducing crime and so reducing the victims of crime. Parole has a role to play in the reform process. It can provide two things in desperately short supply: space and hope. Even if the government were to decide tomorrow to recruit the staff required, it would be many months before they were operational on the wings. Recruitment and training needs to be improved, not rushed. And to neglect that would be to deal with immediate problems at the expense of further problems in future. If staff numbers can't be quickly increased, then prison population needs to be reduced. To be clear, I don't think it'd be right for me, as chair of the Parole Board, to advocate radical sentencing or population management changes, although ministers ought to be looking at all the options. But I am saying that we should ensure that people are not kept in prison as a result of administrative delay, and measures already under consideration to deal with some perceived injustices need to be expedited. Just doing that would ease some of the pressures. I know that some IPP prisoners and others have simply given up hope they will ever get parole. Now, coincidentally, when I was in Canterville only the other day, I met a guy who told me just that. He told me he'd given up hope of ever getting parole and he was going to get himself put in a seg and go on hunger strike in protest. I said rather weakly to him that perhaps he could write me a letter instead, but I don't think he was having it. And of course the disruption that's happening in Canterville now, I don't think is going to help him get through the process. The ability to hope is part of what makes us human. It was expressed very well by Judge Power Ford of the Republic of Ireland in the Grand Chamber of the European Court of Human Rights in 2013 on the case of Vintner and others. I don't want to get into the specifics of that case, which is about whole life terrorists. But what he said about the importance of hope is relevant to all those serving any kind of sentence of whatever length. He said this: hope is an important and constitutive aspect of the human person. Those who commit the most abhorrent and egregious of acts and who inflict untold suffering upon others nevertheless retain their fundamental humanity and carry within themselves the capacity to change. Long and deserved though their prison sentence may be, they retain the right to hope that someday they may have atoned for the wrongs which they committed. A prison in which prisoners feel, like the guy I met in Canterville, not like the guy I met in Canterville, that they have some hope for the future of a different life, is likely to be safer than one in which people feel hopeless, I think. A prison in which long-term and therefore more mature prisoners have a genuine interest in making progress is likely to be one in which a rehabilitative ethos can be more easily established than one in which a significant and influential part of the population feel it's all pointless. Google parole, and you get lots of different meanings. In its original sense, it meant the conditions applied to release prisoners of war. Look at discussions in the States about it, and it seems to be mainly about whether a prisoner is deserving of mercy or forgiveness. I think many people in England and Wales assume it is something prisoners serving a long sentence can earn through good behaviour. For many professionals, it's often about whether they're able to apply the work that will reduce the prisoner's risk. There should be elements of all of these things, I think. But many prisoners feel, I know, sometimes with justification, that it's an arbitrary process that, provided they stay out of trouble, does not depend on what they do, but on whether a remote offender manager or the system slots them into programs or the type of prison they need to experience to demonstrate to the parole board that their risk has been reduced. And risk is assessed to within a single percentage point by algorithms heavily dependent on a prisoner's past history, which of course they can't change. Past behaviour may be a good predictor of future behaviour, and assessing risk is important. But as I argued earlier, a view that sees prisoners as simply a product of events and environments beyond their control also denies the possibility of them being agents in their own change. And I prefer to see prisoners as individuals who made bad decisions in the past, but who possess the human capacity, should they choose to use it, to make better decisions in future. I suspect that many of you here will only have a vague idea of what the Parole Board does. It was established by the Criminal Justice Act 1967, so next year is our 50th anniversary. And you'll be pleased to hear I'm not going to ask you for any birthday presents. Of course, its role and scale of its work has changed enormously in that time. In 2015-16, the board held over 7,000 oral hearings and dealt with some 16,000 cases on the papers. It currently releases about 40% of the prisoners who come before it. The Parole Board is an independent, court-like body that's sponsored by the Ministry of Justice. Now, I am confident that the Parole Board makes its decisions independently. Nevertheless, it is a legitimate concern, I think, that an independent court-like body is sponsored by the Ministry of Justice, has its members appointed by the Secretary of State, and is based in MOJ headquarters. I don't like any of that. But frankly, given the amount of urgent work we've got to do, it's not an issue I'm going to address in the very near future, but I'll put that marker down. Today, the remit of the Parole Board is as follows. Deciding whether to release indeterminate sentence prisoners, including life sentence prisoners and prisoners given indeterminate sentences for public protection after the minimum term of imprisonment has expired. Deciding whether to release some categories of determinate sentence prisoner. Deciding whether some prisoners who have been recalled to prison can be released. Advising the Secretary of State whether indeterminate prisoners can be moved from closed to open conditions, and advising the Secretary of State on any release or recall matter referred to it. And in deciding whether to release a prisoner, the board has to decide whether it is satisfied that it is no longer necessary for the protection of the public that the prisoner should remain detained. It's the test that we have to apply by law. In effect, what that means is the prisoner has got to demonstrate that releasing him or her would not create a risk of serious further offences, rather than those opposing release being required to demonstrate it would do so. The problem for the prisoners is how do they prove a negative. You can see here how the workload of the Parole Board has increased in recent years. This chart shows the effect of the decision in the case of Osborne and others, which required the board to hold more staff and member-intensive oral hearings, and led to an increase in the board's backlog of outstanding cases. So those blue bars are the board's backlog of cases. And then said below the dotted line is the sort of frictional level of just cases that are being processed. All of the stuff above the blue line, or above the dotted line, is sort of delay. And you can see how that delay really climbs after we had to have a lot more oral hearings but don't get the resources to deal with it. And you can see now it's starting to slowly come down. I support the principle of more oral hearings, but at that time the board wasn't given the resources it needed to cope with that increased workload, and so as you see, the backlog grew. The board's got a 5-point strategy going forward. One is we're going to safely eliminate the backlog of outstanding cases by 2017. We can get rid of that backlog. All those people waiting desperately for their cases to be heard, we can sort that. We're going to focus on the cases where we think we make most effort, such as IPP prisoners. We're going to work with others to make sure that IPP prisoners by 2017 will either be released or have clear plans that will enable them to progress. We're going to look at the whole business of how we assess risk, and we're going to get members and staff working together more efficiently, I hope. We're making progress on all of those things. This is the Pro Board's kind of backlog. And the green line is where we think it's going to go, and we're ahead of schedule. And we think that by the end of 2017, we'll have got rid of our backlog. Now, I should say, actually, this is almost nothing at all to do with me. My predecessors laid the foundations by taking some tough decisions and putting new systems in place. And Martin Jones, who's here today, the Pro Board's chief executive, and the board's truly impressive members and staff, worked incredibly hard to turn this round, and I pay tribute to them. Now, I know there's many people in this room concerned about IPP prisoners. The imprisonment for public protection sentence, the IPP sentence, was created by the Criminal Justice Act 2003 and implemented in 2005. The sentence was curtailed in 2008, and it was finally abolished in 2012. And it was intended to ensure that dangerous offenders were detained until their risk was manageable in the community. But the whole thing was used much more widely than had originally been anticipated. The sentence is in two parts. The first part is the tariff or punishment part of the sentence, which is the minimum period that the judge says the prisoner must serve before they can be considered for release, and post-tariff. The risk of after that period, post-tariff, the risk test applies, and the prisoner can only be released if the parole board is satisfied that he or she no longer poses a risk of committing a serious further offence. So said, the sentence was used much more widely than had been anticipated and was subject to widespread criticism by the courts, Parliament and some in the media. And to be frank, the prison service struggled to put in place the offender management processes and programmes to help prisoners reduce their risk, and the parole board struggled to keep up with its increased workload. So we're saying that before the sentence was curtailed in 2008, prisoners had very little, judges had very little discretion about the use of IPP sentences, and up to that point it was available for relatively minor offences. There was no minimum tariff, so some IPPs were imposed with extremely short tariffs. Infamously, the lowest period to be served was just 28 days. So although you get a 28-day tariff, that might not mean you get out for years and years after that. Yeah? The release rate was low. In 2010-11, the board released just 140 IPPs. At the point of abolition in 2012, December 2012, there were just over 6,000 IPP prisoners in prison. Since that date, the number of IPP prisoners has fallen by about a third. According to the last published data, there were just about 4,000. You can see what's happened to the IPP population here. This is like indeterminate sentence prisoners, so life prisoners and IPP prisoners. And you see once the IPP sentence is introduced, the numbers rocket up, right? Putting huge strain on the system. And a slow decline now. And this shows you a bit about how the parole board has been handling IPP prisoners. So the orange bars, the tall orange bars, right, show the steady increase in IPP prisoners considered for release as more and more reach the end of their tariff. And the green bars show the increase in the actual numbers of IPP prisoners released. And that number's increased from 140 in 2010-11 to 715 in 2015-16. And the solid brown line is the percentage, the release rate, right? The proportion of IPP's cases considered that result in release. And that's now just under 40%. So we're seeing more cases and releasing more of the cases that we see. And we're still keeping, I have to say, the serious further offence rate to less than 1/10 of 1%, probably terrible though those cases are. There are now 3,263 IPP prisoners, 82% of the IPP population still in prison, and now post-tariff. So 4 out of 5 of every IPP prisoner in prison is now beyond the end of their tariff period. Okay? The overwhelming majority of them are held in closed conditions. There are still 667 IPP prisoners who had a minimum tariff of less than 2 years. So they must have been sentenced before 2008. And they've still got, and yet with a minimum tariff of less than 2 years, and they're still there. On the other hand, there are also 730 who've not yet served their minimum tariffs. And some of those people, I think, it's reasonable to assume, would have received a discretionary life sentence if the IPP sentence hadn't been available. Broadly, and this is an oversimplification, you can think of IPP prisoners in 3 groups. Right? Firstly, there are those who we can be confident no longer pose a risk. Prisoners who are safe to release as soon as they reach the end of their tariff and we can hold a hearing. Okay? On the other hand, there is a group who continue to pose a very serious risk, and it's difficult to see how that's going to reduce to a safe level for many years. And let me be clear, the Parole Board is not going to release individual prisoners or recommend the release of categories of prisoners we think continue to pose a serious risk. But in the middle is a much more complex group. Prisoners with mental health problems, for example, or prisoners with chaotic lifestyles who are unlikely to be model citizens, but who do not pose a risk of serious further offences and could be managed in a community if the right supervision arrangements could be put in place. Let me give you an example of a case I sat in on the other day. An elderly and frail sex offender with early onset dementia. At the hearing, confused even about where he was. His very frailty reduced the risk he posed, but nevertheless, he might still pose some risk to children he came into contact with. The panel concluded he was safe to release if a care home could be found that was willing to take him and could ensure he didn't have any contact with children who were visiting, for instance. And therein lay the difficulty. Was there a care home that was prepared to take him? Eventually, after a lot of good work by the probation service, such a care home was found. But there'll be other cases where men remain in prison needing high levels of care because no suitable community placement is available for them. And there remains a case, I think, sometimes that coordination between the Parole Board, probation service and prisons needs to be improved further. And sometimes inadequate coordination leads to unnecessary deferrals and adjournments. Another issue is the reductions in the use of release on temporary licence, or ROTL, create significant problems for us. I think the management of ROTL did need to be improved, but now the restrictions are such that it makes it much more difficult to assess a prisoner's risk by seeing how they behave away from the prison environment. As I said, if the Parole Board can resolve some of these issues and continue to make the progress we've been making already, and if nothing else changes, we estimate we can get the number of IPP prisoners down to about 2,000 by 2020. Initial releases, though, aren't the end of the story. It's now a growing number, and there's now a real problem with the growing number of recalls. released IPP prisoners remain on what amounts to a life licence. And licence conditions can lead to individuals being recalled to prison, and potential breach of licence conditions can lead to individuals being recalled to prison, and potentially then the whole parole process has to start again. The licence period is too long, the bar to get recalled is too low, and the recall process itself needs greater procedural safeguards. I'll give you an example. It's not an IPP prisoner, but it makes the point. Something I heard about in an approved premises I visited. And the manager there told me about the man. In this case, he was a man on a determinate sentence who was staying in these approved premises till the end of his licence period. And then at the end of his licence period, he had to move out into his own accommodation. And then 2 days before the end of his licence period, at the weekend, he goes out on a bender and doesn't come back to the hostel. Unfortunately, the offender manager, and the manager I met, was a very impressive woman, but she wasn't on duty that weekend. So the offender manager who deals with the fact this guy's gone AWOL isn't someone who knows him at all. So better than safe than sorry, she thinks, and gets him recalled. So he disappears back into the system 2 days prior to his licence ending, for years, probably. And what the offender manager woman I was talking to was saying, look, if I'd been on duty, I would have let him sweat it out in the cells a bit, then I would have got him back in here, I would have given him of his life, and then I would have talked to him about why he was so anxious, why I'd gone out on the drink, and what we were going to do to move him safely into the accommodation that was causing him all of that anxiety. But as it was, he was lost. And that happens. We see that pattern again and again. So as a result of all of that, real pressure for reform has built up. And in May this year, in a speech to the prison governors, Michael Gove, the previous Secretary of State, said this. He said, more still needs to be done, and I've asked Nick Hardwick to help develop an improved approach to handling IPP prisoners, which keeps inside those who pose real risks to the public, but gives hope and a reason to engage in rehabilitative activity to the majority. I have to say, in fact, he didn't ask me to do that. This was the first I heard of it. He never asked me anymore, but I decided that I was going to ignore the fact he hadn't really asked me to do that and act on the basis that he did, and I told him and his successor what I thought should happen anyhow. But if you want to see some official inquiry, you're going to have a long time waiting. I never got round to doing it. But I'll tell you what I thought anyhow. And this is what I said. First, there are things that the Parole Board can do itself or by working with others to reduce the numbers of IPP prisoners still held. These are the sorts of things we're doing. I'm not going to go through them all now, but I've said if we do all of these things successfully, we can reduce the IPP population to around 2,000 by 2020. It was 6,000 at its height, it's now about 4,000, we can get it down to 2,000. But if ministers want to go further or faster, it will require legislative or policy changes. And these are some of the options that they've got. First of all, conversion. They could convert all or some IPP sentences to a fixed-term sentence with a definite sentence end date. They have a sunset clause. Establish a provision to provide that all or some post-tariff prisoners must be released no later than a certain date. They could do something with a risk test, reverse the risk test for some or all IPPs, so that the Parole Board has to demonstrate that the prisoner poses a serious risk, rather than the prisoner needing to demonstrate that they do not. And the Legal Aid Sentencing and Punishment of Offenders Act 2012, LASPO, gives ministers the powers to do this. And so far that's not been used. They could use executive or compassionate release, which we think would be particularly valid for those IPP prisoners who have now served more than the maximum tariff that's currently available for their offence. So they've done longer now than someone who committed the same offence could possibly do. There are short-term IPPs. Those prisoners, we think there's an argument for reversing the risk test for IPPs with an original tariff of less than 2 years. And recalls. We think that the IPP sentence should end once the Parole Board has decided on release, and we should deal with any further offences, or any further offences should be dealt with under normal sentencing provisions, and licence period should be limited. Now these are options, they're not recommendations. I don't, to be frank, think the first three are terribly realistic in the current, likely in the current circumstances, either because I don't think there's a legislative opportunity to make them happen, or because they involve releasing prisoners who remain plainly dangerous. And I don't think that's going to be acceptable, to me, frankly, as much as anyone else. But the bottom three are more doable. Compassionate release would involve a relatively small number of prisoners who are serving an IPP sentence, who, as I've said, have now served longer than the maximum sentence available if they committed the same offence today. And that just feels unjust to me. Dealing with short tariff IPPs, the 700 or so who, before 2008, don't forget, received the sentence with a tariff of less than 2 years. I'm not suggesting they should be automatically released, but there is a case that for this group of prisoners, whose tariff suggests that they committed relatively minor offences, on this occasion at least, it should be for the state to prove they pose a serious risk rather than for the prisoner to prove that they do not. And LASPO already gives the Secretary of State power to do that. It doesn't require legislation. And then we think something urgently must be done about recalls. And I think, at the very least, establish a position that the first time an IPP prisoner is released by the Parole Board, their IPP sentence ends. And if they commit further offence or breach of their licence conditions, they should be dealt with according to current sentencing options. These measures would not completely resolve the IPP problem, but by quickly getting some cases off our books, it would free up resources to focus on and make progress on more complex cases. My approach to prison reform and the role of the parole system within it are the same. I recognise there are formidable current difficulties. We should be mindful of the concerns of victims and we should manage risk carefully. But I do believe that change is possible. We should not lose hope. It is possible to make prisons safer and to push ahead with the wider reform agenda. We can make substantial progress on the IPP issue. Successful reform of any type in any situation needs both vision and a practical path to delivery. We've done the vision thing, I think. Now I'm hopeful we can turn to delivery. Thank you.
That's fantastic. So many, I've made notes, there's so much in there. Now, I didn't actually ask Nick whether he was going to take questions, I just assumed he was, and he's just agreed to.
Martin will answer.
Can I get an indication of how many people want to ask a question? So I can see, I thought there might be a few. So I'll take 3 at a go. We do have microphones. I would ask you to do 2 things. First of all, say who you are, and secondly, to be very, very brief. I do not want to hear your life story, fascinating though it may be. Right, put your hands up again. We'll start over here, chat there, and I'm going to then I'm going to move my way across.
Yes, good evening. Good evening all. Can you hear me?
Yes?
First of all, I've taken
Name?
most notes. My name's Philip Pryor, by the way. I am a member. I've come here a few times. I have written a letter to Mr. Hardwick a couple of years ago when he was...
I'm going to ask you to be very brief and just ask a question.
Sorry?
I'm going to be very tough and just ask a
Yes.
question.
You say there's hope. Can you elaborate on what you mean actually by hope? By the way, I'm an ex-prisoner that's destroyed my life. In prison, doesn't work.
I think we'd all agree with you there. Can you pass the microphone on to the next person? Thank you. I'm moving this direction. There's a lady here in the front. That's it down here. Thank you. And then there'll be, yes, and then there's a lady behind in a black top.
Hi, my name's Candy Whittam. I just wanted to know what I could tell some of the IPP prisoners I work with, what you meant by clear plans when you were...
Good question. Pass it back and there's a lady behind, so that'll be 3 questions.
Hi, Prem Anawallia from Garden Court Chambers. My question's about IPP prisoners And those for arson offences in particular, what's the way forward? Any suggestions there?
Very tricky.
Well, first of all, in answer to Philip's question, if you wrote to me, I would have replied. I saw every letter I addressed to me as Chief Inspector of Prisons, and I replied them all personally. I hope I did explain what I meant by hope. I do think, not for everybody, certainly what I was really impressed with in my time as Chief Inspector was by prisoners, some of whom had had the most dreadful experience and their ability to make kind of new lives for themselves. And hopefully that's what I was talking and elaborating on a bit during my whole presentation. In answer to, I didn't quite get that, didn't get your name, I'm afraid, the second question about clear plans. That is it's a very important point, which had I had longer, I would have elaborated on. I'm not saying I think that we can get every IPP prisoner to a point where they're released. What I am saying is I think every IPP prisoner ought to know how they can progress from where they are now and what they need to do to achieve that and how they can have some control over their destiny. So if it's a case, for instance, of someone there'll be IPPs in Cat A, well, what do they need to do to get to a Cat B? If they're in a Cat B, what do they need to do to get to a Cat C? What are be clear about that the plans that are there to enable them to progress are actually achievable for them to do. And I think the numbers, if we can get rid of some of the easy cases, but what I think is that for some of the more complex cases, it's possible to have much more detailed and individual planning for them. I'm not sure that's the role of the Prof to actually do those plans, but certainly I think that the probation service can do those plans in a way that's not actually happening at the moment. And it's a very big question you've asked, and it is something I'm sure colleagues Prof would like to talk to you about in more detail. It is something that we take very seriously. And then there's a question again, Fred, I didn't catch your name, about arson. I think arson is a real problem simply because of the difficulty of getting any kind of move-on accommodation. I guess that's one of the issues in terms of free premises and accommodation and other things. I think that what's really important, I think, is that assessments of people's risks are done on a very individual basis. One of the dangers, I think, is if you have a particular sort of offence that then creates a certain has a particular implication when your algorithms are done about your risk, then almost the situation is taken out of your own hand. So I would say on arson, I think, there's issues around move-on accommodation, which I think are going to be very difficult to deal with. Where do you live after you come out of prison? But there are also questions about how people with those sorts of offences, risk is being assessed and whether that's done in the best way. And I say I wouldn't claim to be an expert on that, but I think that'd be something we'd be interested in having a conversation with you about further. Actually, if you've got a particular interest in that, I would certainly like to know more about it.
I remember one of the very first cases we dealt with in our legal team was a 17-year-old girl who'd had her baby taken away from her by social services. I don't make any judgment on that, but she'd gone into the social services department and set fire to a waste paper basket because she was so angry. She got a life sentence for arson. That was 10 years ago. She's probably still in. We lost contact with her. So it depends what the arson.
Yeah, it does. I think lots of these.
Context.
I think lots of these things. You have a broad term for the offence that actually covers a whole multitude of different circumstances. I think that applies to lots of offences apart from arson.
Right, I'm moving in this direction. We've got 2 at the front and 1 at the back. Just lady at the back and 2 at the front. So you can split the microphones. And whoever gets the microphone first gets to speak first. Lady at the back got it first.
Hi, Christabel McCooey from Goldsmith Chambers. Do you think prisons should eventually be abolished? What's the very end goal or vision?
And 2 gentlemen at the front.
Roger Hovell. There's a line in Hamlet about letting dangerous men go free. It seems to me that it's all about prison numbers. Crime has dramatically fallen. Penal populism. How can one educate the public so that it is reflected by the political decisions that prison numbers are reduced?
I'm Chris Naylor. I'm a nearly retired consultant obstetrician. One observation, I'm pleased to say I see a baby here today. I think that's very encouraging for the Howard League. My first point is, do you think the increase in violence is due to the use of SSRI drugs for the treatment of depression, and that in healthy volunteers it's been shown there is an increase in suicidality and violence? And the third point is hope for the future. Do you think there's a room for gene cutting? It's used in non-conventional warfare to increase the sight of soldiers. Should it be used in prisons in the future?
So I'm not going to help you out.
Well, okay, in answer to your questions, Chris, I think about abolition. No, I don't believe in prison abolition. I think society does need a way of setting, saying what's acceptable and what's not. So I think there's some people that are dangerous, and I think prison is the right place for them. I'm not sure we should have prisons in the way that they are at the moment, but I'm not an abolitionist in that sense. Roger, I think, asked about public opinion. I'm very suspicious about this piece about public opinion. As I said, if you look at what concerns the public, the Murray polls about concern about crime has fallen dramatically. I don't think we should. I think there's a danger that not just the red tops, but the people in this room assume the public are more hostile around prisons and crime and those things than actually they are, right? I think there's more to be done about simply explaining to people what's happening. I think it's possible now, in these circumstances, to have a more sensible debate. I think the tide of public opinion, internationally and nationally, is moving in our way. And I think if we, part of my anxiety, we'll all sit down on our hands, because it's easier to say, oh, well, nobody agrees with us, it's hopeless, we can't do anything. No. This is the time to push on. Drugs all sorts of drugs are certainly a cause of violence in prisons. I'm very dubious about measures that take away an individual's own control over their own destiny, either by drug therapy or any other kind of thing. Actually, I think my instincts, I don't claim to be an expert in what you talked about, but my instincts would be to be very wary of what you suggest, if I've understood it properly.
Right, I'm going to take one more group of questions. There appear to be 5. So you'll have to, and 6. Well, it depends, you see, and you're eating into your drinking time, so you're all being very virtuous. Right, okay. We'll do the little group of 3. You've got the microphone there, so there's a lady and a chap, and then another lady. We'll do 3 and then we'll see how we go.
Is it on? Yeah.
By the way, those of you who are trying to escape, you are being asked for your membership forms as you go out. Right? You're not going to escape easily.
Okay. Deb Borgan, I'm a probation officer working in the male estate. My question is, you mentioned the loss of control in prisons at the moment and how it is impossible to do rehabilitative work at the moment and the volatile nature of the prisons. Under the offender management review that's coming in next year, the move is to put an increased number of probation officers, some who are newly qualified, some who don't want to work in prisons. Is it right to be putting more probation officers in prison at a time when the system is so unsafe for staff currently working in the prisons? Thank you.
And the chap behind?
Yes, Mike Guilfoyle, former probation officer and magistrate in South East London. Simply, the Justice Select Committee report on the role of the magistracy supported the increase in the sentencing powers available to magistrates in the courts. Is this good for justice?
That's nice and easy. No. Sorry.
I'm Sandy O'Leary, mother of a prisoner. I just noticed as a footnote on one of your slides, you had electronic tagging, the pilot on electronic tagging. I wondered if you saw the parole board having a role in that, and if it does, whether you have resources for it, given obviously the enormous caseload you have with IPP. Thank you.
Three very interesting questions. I mean, first of all, the question about the offender management review, people won't know enough about that, I think. But essentially, in principle, I think it is a good thing if the responsibility for managing a prisoner's sentence is done by trained professional probation officers based in a prison, rather than prison officers who aren't trained and don't want to do it. Right? So I think, in principle, this is a move in the right direction. Certainly when I was Chief Inspector of Prisons, there's no disrespect to prison staff, but we always found that trained probation officers did it better. Right? There's then a whole set of questions. I've said, I think there are some positive ideas out there about how things can improve. I think you've got to sort out the violence and safety question for staff and prisoners first. So I don't think... So they're both interdependent, I think. On the question of sentencing powers, I'm generally instinctively against more sentences, really. That'd be my position. Or to look at each case on its merits. On the question of tagging, there are new tagging powers. It's a good point. My view on tagging in the parole board is not that it would be some sort of mass thing for thousands and thousands of people, but I think there are a relatively small number of cases where tagging would provide the ability to monitor closely and provide reassurance that would enable some people to be released who wouldn't otherwise be the case. So I think the way that tagging has been done up to now, people think of it is some sort of failed IT system that applies to tens of thousands of people. I think there is an argument for using it, and we are starting to use it now, as a much more specialist and targeted resource that enables us to manage, or enables the safe management of people in the community who otherwise would continue to be locked up in custody.
Right, another quick lot. 2 there and 1 here. 3 chaps. You got there first.
Ryan Wilson, student at Birkbeck University. What are your thoughts on the British penal system's sentencing towards escape, and could we learn from the German philosophy towards escape, which is that it's part of our human nature to want to be free, and it's not sentence? And secondly, just a quick one, why can we not train prisoners to be probation officers and work on the parole board, budget permitting? It wouldn't be the blind leading the blind, it would be, the people with sight leading the people that need to be sightful.
Okay, you've got 2 here.
Hi, excuse me, I'm Tony Mcclain. I'm part of Contact for a small but fast-growing group of volunteers who are going into prisons with something which provides hope and increase in self-esteem. It's called the Peace Education Programme. I'm having great success. Well, from small beginnings, I'm having great success. I'm dependent on volunteers. I've recruited 120 or so to go into the prisons myself. I'm seeing that the possibility of much greater expansion in this because it's free. Can you, with your great experience, please recommend me the best way of continuing? I'll do the work, you just give me your experience, the best way of recruiting volunteers for this.
Greg.
Thank you. Greg Fox-Smith, criminal solicitor and Howard League member. Nick, you told us that you had heard, if only indirectly, from Michael Gove, and members here will probably remember Michael Gove speaking at the Howard League event. What I wanted to know is, Nick, have you heard directly or indirectly from Liz Truss? And Francis, have we heard anything from Liz Truss yet? What's the direction of travel?
In answer to Brian's entertaining question about escapes, I'm not in favour of escapes because I don't think people should be in prison unless they need to be there, as it were. So actually people who are in prison should only be in prison if you need to be in prison, and therefore escape would be a bad thing, I think. But I think we should, there's a whole point about distinguishing between escapes and absconds and people coming back a bit late from day release and whatever, but I'm not, obviously escape isn't a good thing, at least from my point of view. I think in terms of ex-prisoners, I think the point is that we should reduce the restrictions on ex-prisoners doing anything, actually. I think people should be chosen on their individual merits, not chosen because they're an ex-prisoner, but chosen because they have skills or experience they can offer the particular thing. I'm slightly worried by somebody who says, I'm an ex-prisoner, I can therefore explain prisoners to you, because every prisoner is different. But sometimes what I've got here is I'm an mechanic. I'd be very good at fixing a car. I just happen to be an ex-prisoner as well. Or I'm very good at interpersonal skills. I just happen to be an ex-prisoner as well. So in that case, I would try and reduce the restrictions on what ex-prisoners can do. Tony's point, see, I wouldn't. My answer to that is actually, this is where I think I would give, it's about autonomy for governors. I would say it's down to individual, I would like to see it much more down to individual governors, the voluntary and community groups they work with, rather than someone in Whitehall sitting and trying to decide it from the start. I think you should be pitching to an individual prison. They should be deciding whether what you offer helps the prisoners in that particular prison, and that's how it should work, not an over-centralised system. But my point about volunteers, since you asked me, is my experience is people volunteer, the sort of tone of volunteering, do volunteering because it's good for you. It'll make you a better person, because really you're probably unemployable. That's why you should go and volunteer. It seems to me a deeply off-putting message. People volunteer because they want to change the world, in my experience, and a good thing too. Greg's point about Liz Truss, I didn't mention Liz Truss. I have met Liz Truss. I have to say, I think people are jumping to, I don't want to pat on, people are jumping to conclusions about Liz Truss. Certainly I think, so my experience of her, very focused on delivery around the sorts of issues that are of most concern around safety. So I think, it's early days yet, don't proof of the pudding and all of that, but it's certainly much too early to write off. And if actually what happens, and I certainly think it would be a good thing now to move from, we've done rhetoric and vision. What I personally would now like is a bit of heads down delivery. And if that's what she's offering, good.
The answer to your question is we did a fringe meeting at Tory Party conference with Sam Gema, and I spoke with him there and met him there, and I have a formal meeting, which is a sort of dance we do with Secretaries of State each time they come in, but I have a formal meeting next month with her arranged, so we will talk to her, and I have had correspondence with her backwards and forwards about some ideas that we wanted to put to her, and we are developing a plan of action for her, so I will go with, I've got an idea. Thank you very much for coming. It's been a fantastic meeting and lots of very interesting questions and ideas coming from you. Nick, you're absolutely fabulous speaker. Thank you very much. As I say, my staff are there. Look, you're not escaping unless you give them your form on the way out before you get your drink. But thank you very much indeed for coming, and thank you, Nick.